Zana, kita dah mula ke live on YouTube?
Dah, Prof.
Dah mula ya?
Ya.
Oh, okay. Oh, just about to start. Dia lag sikit.
Oh, okay.
Okay, thank you. Alright, boleh kita mulakan ya, Dr. Khairul?
Ya, boleh, Prof.
Okay. Okay, bismillahirrahmanirrahim. Assalamualaikum warahmatullahi taala wabarakatuh. Selamat tengah hari, selamat sejahtera kepada semua audience, peserta, rakan-rakan pensyarah ahli akademik yang dapat hadir dalam siri webinar yang dibawa khas kepada anda semua oleh Pusat Pembangunan Kecemerlangan Akademik ataupun Center for the Development of Academic Excellence, CDAE. My name is Abdul Karim Alias, the Director of CDAE, and this webinar series are part of the program that we designed as part of a professional development program for our academic staff. But to benefit more people, we also open this webinar through YouTube, live streaming to YouTube, and we invite also other academics all over Malaysia from other institutions also to join our session this afternoon, because especially for this topic, which is very important, and I can see the importance and the significance of this topic, and Dr. Khairul can see in the WebEx now is already more than 200 people. So I guess this is a very important topic for everyone, especially for academic staff, and there are recently some new issues coming up. It's very, very critical, very vital for us to really understand the nitty-gritty of copyright as well as plagiarism. And once we understood the nitty-gritty of copyright and plagiarism, we are in the position to also advise and guide our own students. So we don't want the blind to guide the blind. So that's why we need to learn at least some basic and rudimentary aspect of copyright and also plagiarism. I believe copyright is not a black and white thing. It's always, there's a gray area. When there is a gray area, we need a lawyer. And therefore, who is more qualified and more eligible to talk about copyright? We have our distinguished speaker that we invite for the session, our very own lawyer, Dr. Khairul Anwar Cik Azmi. He's a penasihat undang-undang, University Science Malaysia. I think some of you probably already know him and maybe have met him to get advice on intellectual property. Because Dr. Khairul received his PhD actually in the intellectual property area. So he's the most qualified person, at least in USM, to guide us anything on copyright as well as plagiarism. For information for Dr. Khairul's information, I have promoted this event, the session this afternoon, to as many far and wide to my circle, and also I've asked other people also to share far and wide, because I believe it's not easy to listen all these things from the horse's mouth, from the expert. So thank you very much, Dr. Khairul, for accepting our invitation again. We had this session last year, if I'm not mistaken, and today we have this session again. Plus, maybe I have asked Dr. Khairul to cover some new issues which recently crop up. And I would encourage everyone, the audience in this WebEx as well as on YouTube, to ask questions. Just post the question in the chat box, but please put Q capital letters in front of your question so that we can easily identify which is the question, which is just a comment. And for those on YouTube, don't worry, your question there will be copied Puan Rosanna here, our staff, will copy the question from YouTube to our WebEx so that we can also address the question from YouTube. So with that being said, once again, thank you very much, Dr. Khairul, and I think that much introduction I can give to Dr. Khairul, because I think I will let Dr. Khairul to say more and to introduce a little bit more about himself and also to carry on with the session. So silakan, Dr. Khairul, thank you so much. Silakan.
Okay, thank you very much, Prof. Karim, Director of CJE. I guess this is the third time Prof. Karim has invited me to the webinar organized by CJE. It's an honor to be in the session with Prof. Karim because he has a lot of experience, very vast experience in terms of online learnings, etc., which is also related to copyright. So let me allow me a minute to share the slides with you. Okay. Right. Now let's
Okay, can see the slide.
Sorry. Okay. Yeah, I can see the slide because quite nervous to look at the slides. Okay. Yeah, because always have a problem.
Dr. Khairul,
Yes.
saya nak tanya, participant dia orang nampak dekat chat box dia orang ada to everyone tau. Sebab saya takut dia orang chat nanti hanya
tak, saya tak dapat. Sebab tu saya hantar tadi privately. Memang tak ada to everyone.
Apa yang kata ada?
To everyone.
Tu sebab sekarang ni saya tak pasti default Webex tu macam mana. Saya dah buat public dah. Tapi ada certain orang yang tak boleh nak reply, nak chat to everyone.
Okay, dah ada dah sekarang. I think should be okay already.
Okay. Minta maaf, sorry.
Okay, tak apa, yeah.
Okay.
So Dr. Khairul, it is actually about the chat box, the setting in the chat box. For those who want to pose a question, they must make sure dia tunjukkan to everyone rather than private. Itu je.
Okay, understood.
It's not your problem. Okay. Thank you. Yeah, carry on.
Also, I'm not sure what is it all about. Tapi just a self confession, the speaker doesn't have Facebook, so tak pasti macam mana how Facebook looks like and also how Facebook's being governed lah. Okay. Thank you very much, Prof. Karim. Let us start the sessions today. I'm also very obliged my Sifu, Professor Datuk Sri Mat Saleh Jaapar, also in the webinar. I can see him just now, and a few of and a few of our friends from Fauzi nampak dan sebagainya. Okay, let us begin to understand what is the copyright and plagiarism. This is a session for roughly about 2 hours. We will try to finish it within 1 hour and a half so that we can have ample time to start with the Q&A sessions. I will try to take up the most possible Q&A that are going to be posted by you from time to time. But maybe also at the end of the session, if we have time, the last 30 minutes, we may also open up for physical discussions in case you have a very situation to be shared with others as well. Okay, yes, I'm aware that this session going to be open to all, but the few of my slides are talking about USM per se. So let us discuss with policy against plagiarism. Some says that this is policy on plagiarism, etc. But here, when we consulted the pakar bahasa, we've been advised that the policy should be named as a policy against plagiarism, or in bahasa Malaysianya, policy terhadap ciplakan. So the questions to all, does your university has the policy against plagiarism? Okay, not all university has the policy against plagiarism, to be honest with you, but majority in 2020 at least, majority of the public university has already governed their policy against plagiarism, but still not the whole 20 universities have their own policy against plagiarism. This is due to 2012 case, which I will share with you at the end of the sessions, whereby in that court case, the High Court has decided that the university has the responsibility to have a policy on plagiarism and make it aware to all the universities academics and students, because without the policy, in case there is plagiarism in that particular university, the court may decide otherwise, i.e. that plagiarism may not be sustainable in a particular case that has been brought to the court. But in the USM context, we have the policy against plagiarism. This is the front page of the policy against plagiarism, Dasar Universiti Malaysia, Universiti Sains Malaysia terhadap ciplakan. This is the cover page. And this is the summary of the plagiarism policy in USM. The custodian of the policy is the DVC Academic and International Affairs, responsible policy officer. That was first endorsed here. It's a revised version of the policy due to the loophole in the first draft that has been used by the university in 2013. So we have revised the version in 2017, and that has been approved in the Senate, to be precise, on 26 January 2017. It has also been brought to our Board of Governors, the Board of the Universities, and has been approved, both the original version and the amended version. And it is in line with the AUKU and also the Act 605. Act 605 is about the Disciplinary Act of USM. Okay, so if you look at the last table, the last column on the table, if you have any queries about the policy, to whom that you should refer to. So here we have actually three PTJs. There is a mistake of spelling there. Institute of Postgraduate Studies, IPS, Legal Office, and also the Academic Management Division. So why is plagiarism policy is important? Plagiarism policy describes the university's strong commitment to uphold academic integrity in relation to the plagiarism. So why this plagiarism policy does not, why the multinational company doesn't have the plagiarism policy? Why the universities in particular should have plagiarism policy? How about the schools? How about the research institute? Do they have the plagiarism policy? That all will be covered in our topics for today. Okay, let us go for plagiarism. What is the definition of plagiarism per se? Oxford University has defined plagiarism as the copying or paraphrasing other people's work or ideas into your own without full acknowledgement. Some says without acknowledgement. But in Oxford University, it says that without full acknowledgement. It is something about copying and paraphrasing others people's work and put it your name onto it, and without citing the original work. That is the definitions given by the Oxford University. The Cambridge University has defined plagiarism as submitting as one owns work, irrespective of intent to deceive, okay, which derive in part or in its entirety from the work or of others without due acknowledgement. It's something to do about due acknowledgement. So indirectly, it is submitting as our work without giving the acknowledgement to the original authors. Okay, and in USM, we have defined our plagiarism to be perbuatan membentang, memetik, menyalin, memparafrasa atau menyebarkan idea, image, proses, karya, data, perkataan sendiri atau orang lain atau sumber tanpa memberi perakuan, rujukan atau petikan yang betul kepada sumber asalnya. In short, it refers the same thing. to the definitions of Oxford and Cambridge, whereby we have been combining and getting all those definitions and make our own definitions by looking at the scenarios happen in the local situation in University Science Malaysia and in Malaysia in particular. So we have plagiarism. What are the other terms of plagiarism in Malaysia? Okay. If you know that I used the word ciplakan just now, okay, in bahasa is called plagiat. Okay, ia juga digunakan sebagai istilah academic integrity. Academic integrity. Okay, so USM has come up with this bunting about this banner about academic integrity and university accountability. So this is the banner of USM, whereby we don't condone the issue of misconduct covering plagiarism, as well as free riderism, cheating in research or publication and other conduct as well. Free riderism in bahasa is boncengan gratis. Okay, so but we don't have the policy on free riderism. We only have the plagiarism, but we do have a paragraph in our plagiarism policy talking about free riderism as well as self-plagiarism. So I will talk about self-plagiarism a little bit later on, and also maybe on free riderism as well. So other terms for plagiarism is about academic integrity. So there is no academic integrity if someone's have breached this kind of conduct. So apart from that, it is called also jenayah academic. Jenayah academic, but this term that may attract others as well that you may not know, in Indonesia, it has also been known as zina academic, academic adultery. So these are the terms that has been used in particular during my experience dealing with issues of plagiarism. Okay, so we come to the first main content of this webinar, whereby what is the definitions of plagiarism and copyright? Okay, is it same, or is it they have differences between these two? Okay, so in this regard, we need to know what are the differences. Of course, we're going to explain to you shortly. But bear in mind, if you are not really aware about what is plagiarism and what is copyright, and you assume that they are the same, it's not. They are not similar. Okay, they are not similar. Okay. Let's understand copyright first. Copyright is the exclusive right given to the owner of a copyright for a specific period. In copyright, in bahasa means hak cipta. It's been governed under the Copyright Act 1987, Akta Hak Cipta 1987, whereby copyright or hak cipta is the right given to the owner of copyright as long as it is original, it is in writing and or in tape or etc. Must be reduced in writing or must be reduced in a particular medium of communication. For example, film, photos, etc., or CD, etc. And it is automatically going to be protected upon creations. Bear in mind, copyright does not have registration in Malaysia, and worldwide there is no registrations of copyright in Malaysia. If you have if you have, let's say, been informed that you must register your article, your book for copyright, actually under the Copyright Act 1987, there is no system of registration. So it means that there's no need for you to register. What you need to do is that it's automatically protected. Okay, you need to know that it's automatically protected upon creation. Why is automatically protected upon creation? It must satisfy three main criteria. One is that it is original. It cannot be copied from others. Okay. Second, it must be reduced in writing or in any medium of communication. For example, that's I mentioned just now, film, CD, etc. And third one, it must be made in Malaysia, meaning that in order to get protection in Malaysia, you must do or author the material, the subject matter in Malaysia. Okay, this is where we need to understand, whereby each and every respective countries throughout the world, they have their own act, they have their own rules and regulations about the copyrights. Okay, if you are, let's say somebody breach your copyright, your articles, for example, in Singapore, and you want to sue them in Malaysia, you can't do that. You need to sue him or her in Singapore in order for you to get the right of the, in order to get your right in terms of that article, and you must satisfy the rules or the law in Singapore in order for you to win the case. Okay, so copyright, when I'm talking indirectly, I'm saying about suing, I'm saying about the court, etc. Mahkamah, ya, whereby there's no such thing in plagiarism, which I will explain shortly. So in short, you need to understand that copyright have the period of time being given to you for protection. Second, it is under the law of Copyright Act. And last one, there is no registration of copyright in Malaysia. It is automatically protected upon creations. So these are the things that in Malaysia, if you see that, what about the Malaysian Intellectual Property Office, MIPO? Are they do they govern the rules on the copyright? And then you must come across something that there must be, you can register your copyright at MIPO, Malaysian Intellectual Property Office. Okay, and somehow you have been looking at this kind of invoice. Okay, Perbadanan Harta Intelek Malaysia is the MIPO just now, Malaysia Intellectual Property Office. If you look at, they have also office in Penang, their head office is in Bangsa. And then how can this invoice come out if the speaker says there is no need to register your copyright? Okay, let's be clear on this, whereby the copyright is automatically upon creation. However, if you want to register it, you are now allowed since 2017, 2017. You are now allowed to register your articles, your books, etc. At the Malaysian Intellectual Property Office for a token of fees as stated here. So how much is the fees? Okay, the fees is about $45. Okay, but if you use agent, it will cost you roughly about 200 to 300 ringgit. And you can register at the MIPO or at their branch office. For example, they have their branch office at Bandar Sunway, Penang, for example. So in this regard, you are not obliged. It's not compulsory for you to register your copyright. However, there's no rules for you if you still want to register it, you can still do it at the MIPO. It is not compulsory. Okay, what are the advantage if you register? The advantage is that you're going to have this receipt, and then it's going to be recorded at MIPO. That's all. Okay, so nothing else. For the sake of MIRA marks, yes, the MIRA committees have put a conditions that in order for the marks to be calculated, you need to register at MIPO. I guess this is one of the ideas of why registering at MIPO was allowed in 2017, in order to safeguard some of the interests who feels that, look, I don't know where to register. Let's have a system to register it, and MIPO take the challenge by the government and open it for registration. The other thing, before I forgot, if you have the registrations at the Perpustakaan Negara, that is not considered at the National Library of Malaysia, that is not considered as the copyright registration. Okay, that is purely for you to register at Perpustakaan Negara, but that is not considered as registration of the copyright. So, how to safeguard your copyright if there is no system for registration? I didn't want to register, but how to safeguard my thesis, even though the speaker has said that it's automatically protected upon creations. Okay, I would suggest you to put a copyright marks into your material, into your thesis, into your journal, into your book. Okay, but as long as this is C in the circle ni exists, it means that this is a copyright. You don't want other people to copy it without your consent. If you want to add up, you can use the paragraph that I have said, that I have provided here. You can add up to your material, saying that all material in this course, for example, unless otherwise stated, the property of your institution or your name, copyright and other intellectual property law protects this material, reproduction, blah, blah, blah. So you can add up this paragraph if you like, but it's not necessary. Even you put it C in the circle, C dalam bulatan tersebut is considered automatic rated. How about if I didn't put any C at all? Okay, it's still automatically protected. Bear in mind, the law says so, not me. Okay, it's still automatically protected. Remember, if you remember your thesis, even though how long you have finished your thesis, there is no C in the bulatan appears on your thesis, but it's still protected until today. You still have your right in case anyone copywriting your thesis without your consent. So bear in mind, it's still protected even though you didn't put the mark. The why we put the mark, just to say to ensure that people who try to copy you understands that you are not allowing that to happen. Okay, where best to put this C copyright? Okay, you can put it as your watermark, or even you can put it at the footnote of your document or at the front page of your document. It doesn't matter. Okay, look at the paragraph that I referred to you just now. It says that all material in this course, unless otherwise stated, the property of your name or the name of your institution. Shall I put my name or shall I put my institution? Shall I put my name Cairo there or shall I put my USM name? Or shall I put both? Oh, okay. Look, the best way to put it both. Cairo, USM, for example. But most of the time, people put it USM. People put it Cairo 2021, for example. It does not matter. But bear in mind, in law, the owner of your material is you, the author. However, if you are author the material during the course of your business, do belong to your employer, to majikan. Okay. For example, now you are under the scheme of University Science Malaysia. We are staff of USM. Okay, so all the materials in the ordinary course of business, meaning that in your proficiency, in your field, in your area, whatever that you have produced, you have come up with something to do with copyright or patent, in fact, it all belongs to USM. Okay. However, you are still owning the material as a moral obligation as the author or inventor of that product or that material. Okay. I will come back to you in my last slides about how sastrawan negara has won a court case for 750,000 because of one of the kerajaan tempatan, in this case DBKL, has violated the copyright of his idea, of his material. Okay, I will come back to you shortly about who owns your copyright. Okay, so what is the duration of your copyright? Okay, if we have a physical meeting, I will always bet for it because most of us didn't know how long, what is the duration of the copyright. At least some of us knows, but it's still not a correct answer. The durations of copyright is 50 years. Okay. However, 50 years started from when? 50 years started from the death of the author. Okay, so you wonder why P. Ramlee, who has passed away in 1974, if not mistaken, still have the royalty being paid to his family because of the durations of the copyright. And in US law, they are contemplating to extend it to 75 years. It's not yet taken place, but they are contemplating to extend it to 75 years. At the moment, Malaysian situations, it is a 50 years from the date of the death of the author. So how about if we have 3 authors? When it started, it will start from the death of the last author. The last author. So if you have author A, author B, author C, author A and B has passed away and author C is still alive, so the 50 years didn't kick off yet. It will kick off only after the death of author C. So what will be the strategy? The strategy will be maybe to revise the book and add up another author, so that the 50 years still didn't kick off. Okay, so that are the some of the things. Maybe make sense to some, but doesn't make sense to in some other situations as well. But bear in mind that it is a 50 years from the death of the author. Now we know the durations of the copyright. Is there a duration for plagiarism then? Okay, so we never heard about the duration for plagiarism. Okay, this is where I'm going to share with you what are the main differences between copyright and plagiarism. There are vast differences between copyright and plagiarism, even though sometimes it has been used interchangeably. Okay, look, plagiarism is an act of stealing someone else's academic work. Okay, bear in mind, copyright is talking about the whole lot in this world. It doesn't matter whether it is a business, stealing the business work or stealing the academic work, etc. But plagiarism is always talking about academic work. That's why we don't have the period of time. How long the plagiarism, duration of plagiarism? It remains as long as there is a fraud or there is a fraud or there is a stealing of academic work, as long as you can prove it. So bear in mind, the first main differences between copyright and plagiarism is that plagiarism talk about academic work, whereby copyright talking about others. Plagiarism does not have any law. Okay, that's why we have the policy against plagiarism. We does not have the country does not have the National Plagiarism Act, for example, whereby we do have National Copyright Act 1987, but plagiarism does not have, because plagiarism is limited to the academic institution. That's why you don't have, for example, Jabil, Panasonic, Sony, that have the plagiarism policy in their companies. Okay, because they are not dealing with academic work. Okay, you don't have any schools to have plagiarism policy as well. You only have plagiarisms at the university level, simply because the universities confer the degrees. Okay, you are talking about conferring the degrees or the academic reputations of a particular individual. Academic reputations including academic posts of a particular individual. So that is the thing that you need to know. What is the main difference between plagiarism and copyright? plagiarism is talking about the academic. So it only happened at the university levels. It does not happen in school, in fact. It does not, it seldom happen in research institute because they don't confer any degree. Okay, it happened only in institutions that have conferring the university degrees. So in this case, I would say plagiarism, you must equate, you must relate it to the conferment of degree. Whereby copyright, if you are not happy, you feel injustice happen to you. You feel something has, someone has violated your rights. Someone have taken your rights, and you want to sue them in court, so that you can be compensated, make money. I mean, it is all under copyright. Bear in mind, plagiarism you cannot sue in court. Okay, if someone notice here, I'm talking about a case whereby in 2012, the speaker just now spoke about plagiarism 2012 case about court decision. Now, in this slide, he said that this is not court matters. Why is it? Okay, I will explain later on while we going one by one of the slide, because we need to understand first before we come out to the real understandings at the end of our session. So, relate to your understanding is that plagiarism is about academic. It's about conferment of academic. Copyright is about you suing in court. Okay, so what are the main difference? If you have a plagiarism issues, a particular issue that you would like to lodge a complaint, you lodge to the authority in that particular institution. For example, if you have a suspicious of a plagiarism has happened in USM, you write to the Vice Chancellor of USM or to the Dean of that particular faculty in order to lodge a complaint on plagiarism. Okay, copyright is not about, it's not simply like that. Okay, a particular publisher can send a notice of demand to the university saying that our academic has violated the copyright of theirs, and then they are talking about RM 10,000 ringgit as compensation. Okay, so it falls under copyright. So in short, even though it's not going to be a blanket differences between these two, I would say plagiarism, if found guilty, it will affect the academic credibility of that particular individual. For example, if he has been conferred a PhD degree, the degree may be withdrawn. If he has been promoted to Professor Madya and if found guilty, the Professor Madya post can be brought over to Tata Tertib and he can be reduction in rank, turun pangkat. So that happened in plagiarism. The plagiarism does not come with he plagiarized my thesis, and for that I'm asking for 10,000 ringgit compensation. No, plagiarism does not work like that. Copyright, yes. Copyright, yes. So if that's the case, if you want to sue somebody because of copying your thesis and you want compensation, you need to sue them under the law of copyright, because the law of copyright is under the Copyright Act. It allows you to get compensation. Plagiarism, no. Plagiarism is talking about academic integrity, whereby the punishment for it is maybe withdrawal of the degree, or the tata tertib actions been taken against that particular individual, and may he or she may have an issue later on because of tata tertib. Let us go to the real situations now, because we are in the midst of the subject matter. Plagiarism, in one particular case, happened at particular university. Because we have many institutions here in the webinar, so I don't want to mention any universities, even though someone can easily assume which university is it. In a particular university, an associate prof was accused of plagiarizing his former student's thesis. Okay, what happened was that the complainant was the students of that particular supervisors, the academic staff. When these students graduated from that university, she found out that her supervisors has published her works as hers. Okay, she has published her works without getting the consent from the students. So the students now, because she has graduated, she went back to her own university, and because of she has graduated, she dared to lodge a complaint to the former lecturer, to the former supervisor. When the university received the complaint, we investigate. We found out that yes, there are bases for the complaint, whereby we found out the let's say chapter 3 or chapter 4 has been taken in verbatim and reduced as an article of that particular supervisors and published as that under the supervisor's name without the name of the students. Okay. At that moment of time, we are trying to see whether there is a room for negotiations, etc., because it's a serious case. I mean, don't speculate. Room for negotiations means that we would like to withdraw. We would like to suggest the supervisors to withdraw that articles or add up the name of the students. But in that particular case, the supervisors refused to opt for any of the option for settlement. As a result, the case has to be brought over to the Tata Tertib. And during the inquiries at the Tata Tertib level, the Jawatan Kuasa Tata Tertib Disciplinary Board has asked why she has reported this to the against her supervisor. She has testified that, look, this is not the first time. This is in fact the second time. The supervisor has done it during her supervisorship, but that was resolved. But in this case, I think she said that I think she will not give leeway on this issue because this is the second time. That was the second time. So as a result, that particular supervisor has been taken into disciplinary and has been terminated from the service. Okay, so that's how serious the universities view the plagiarism issue. Okay, why this case is an example for this? Look, if you are lodging a complaint on the basis of plagiarism, you are not talking about any compensation. You are talking about, look, you want the fairness, the justice to you, okay? Whereby the justice may be in the form of include back your name or withdraw the publication, or maybe say sorry, and then ensure that it will not happen again. However, the fact of the case does not reflect that way because of the unwillingness of the supervisors to do that. But the supervisors didn't know that the consequence of the Tata Tertib is that the supervisor has been terminated from the post. Okay, from the post. But that particular student, if she want to go through court, she can sue that supervisor and ask for compensation. However, in this case, I don't think there will be an adequate compensation in terms of ringgit Malaysia because there's nothing, there's no loss, the real loss in terms of money from the student side. Okay, so the best way to resolve or to settle the case is through plagiarism's complaint, not through a copyright legal way. Okay. Okay. So by now we should understand what is plagiarism and what is copyright, and then there is an issue if there is a copyright, if there is any plagiarism, is there any exception to it? Okay, the exceptions to use of copyright and use of plagiarism is always the fair use. Fair use. What is the fair use? It outlines the fair use is something here. Allow small parts of a piece to be used without permission for the purpose of criticism, commentary, new reporting, teaching, scholarship, or research. Okay, so our most of our defense here in regard to the case of USM, we said that this is for academic purpose, which falls under teaching or research. Okay, but bear in mind, the fair use only allows us to use a reasonable piece of that material, not the whole piece. If you are still copying the whole thing, particularly in verbatim or the whole lot, it still you are not falls under the fair use. Fair use means that you can use it for teaching. If a book, you use it for a certain portion of it for the sake of teaching, not generating any income. As long as there is no income generations, you are not doing business, we can still defend you. We can still have a very good defense in order for that. Bear in mind, if you are thinking now, let's say, how about the many lecturers now using the textbook or reference books from the publishers and then just copyright, etc., without giving any acknowledgement or citations, etc. That's because the publisher allowed that to happen. Okay, so it may also falls under fair use, but in that particular case, we said that it is been allowed by the original author or by the publisher. A simple example for that, okay, let's say you are using my slides, okay, I don't have any C in circles put into any of my slides, okay, but it does not mean that you can use my slide freely. But in this case, okay, if you use my slides, for example, for your own teaching, okay, if I'm not happy also, I just as I will only remain as not happy, but I cannot be compensated. I cannot sue you because you are using it for the sake of your academic teaching. Okay. However, while you are teaching, you are also using the same flights and making money. For example, 10,000 ringgit at Open University, for example only. Okay. So if I'm suing you, okay, I'm not happy, I'm suing you, I can only also sue you, and I can up to the 10,000 ringgit that you have received such benefit, plus some exemplary damages, which will not be more than 10,000 as well. So the most I can get from you, 10,000 plus 10,000. So that will be the amount if I'm suing you. If somebody's suing you, if they are not happy with your use of the copyright things without their permission. So in this case, if you are using for teaching, mostly you here, you falls under the fair use, which is one of the exceptions to copyright. Bear in mind also, even if you have used it, but because of you are not aware about it, the law still allow us to say sorry. Okay, the court will still not punish us. The court will still allow us to say sorry, provided immediately you have to remove all the things that you have been using illegally or unfairly on the copyrights, and do not repeat it again. So that's how it works under the copyright law, whereby the rule of sorry is always a good rule rather than see you in court. Okay, the court allow us to say sorry, provided immediately remove such use of the illegal or the illegal copyright things. Okay, so we come to the type of plagiarism. There are 4 types of plagiarism. You are talking about simple things about copying. So the main types of plagiarism is always this first type, whereby it is copying. You just copy, tiru saja bulat-bulat. Okay, that is the simplest way. You take it from the net and then post it as yours in your thesis. Post it as yours as in your articles without any additions, without any revamp, etc. Just simply copy paste. Okay. The second type is a patchwork plagiarism. Okay. Patchwork. You tampal-tampal sana sini. Okay. And do some basic paraphrasing as well. Okay. That is also called patchwork plagiarism. Do not worry. I will give you an example shortly. Okay. And the third one is paraphrasing plagiarism. This is always paraphrasing plagiarisms. Okay, and the last one is unintentional plagiarism. You do not intend to plagiarize, but somehow at the end of the day, it being plagiarized. Okay, when you go for turn in, it says that it's a 70% taken from other people's work, whereby you don't think so, and it is called unintentional plagiarism, and it still falls under the plagiarism's wrongdoing. Okay. So how to avoid plagiarism? Simple, avoiding plagiarism, simply be honest. You just give credits. You acknowledge and you put the citations. You put the original citations that you have been referring. So that will be simply be honest. Okay. So when you are taking other people's work and you cite it, of course, it should be a reasonable amount of work, not the whole lot. So even though you need to be honest, you need to use it reasonably, not the whole lot. Okay. There's no such thing like this cartoon. Okay. Something you found out something too similar, and yeah, there's no such thing similar in verbatim, for example. Okay. There's no such thing. Okay. So USM plagiarism policies, definitely the objective of it to take care of the reputations of the academic institutions and as well as our academics as well. So that's why this policy is a guidelines as a guidelines to all in order for us and the students as well to avoid plagiarism. So this USM plagiarism policy contains the whole lot. It is about 37 pages. You can download it from our legal office website. You just type legal office USM at the front page of there. At the front page, even the front page, you can click the plagiarism policy. It's in our website. Okay. Okay. We come to the second phase of the importance of this webinar. It's about level of plagiarism. I have to confess that in our first versions of plagiarism policy of USM, we do have problems in order to ascertain whether a plagiarism happened or not in those cases that we have been dealing with. Okay, because some are minor plagiarism, but it's still plagiarism. We said, okay. Some are quite moderate plagiarism, but it can be intentional, it can be significant, it can be deliberate, can be ignorant, etc. So we come up with this chart in our revised version. Okay, if you look at the chart, we have 4 levels of plagiarism that we have developed. Okay, this chart actually has helped a lot to the university, whereby the committee, the investigation committee of plagiarism in USM has relying on this chart. I think a very useful chart whereby we can understand to what level of the plagiarism happened in that particular investigation or complaint. Okay, for example, look at the measurement is on the ignorance and the significance. Okay, whether it's significant, very significant or insignificant, ignorant or some intent or deliberate. If it falls under level 1, which is white in color, yes, plagiarism happened, but it does not warrant a tata tertib, a a disciplinary action to be taken against the wrongdoer. Level 1 also does not warrant a particular thesis to be void. Okay, level 1. Okay. But if it falls under level 2 to 4, level 2 to 4, it is considered plagiarism happened and it need to be taken to the tata tertib, and if it is during the viva session, the viva need to stop. The viva need to be considered as failed if there is level 2 to level 4. Okay. So what are the difference between level 1, level 2, level 3, and level 4? Let me give you an overview on this. If it falls under level 1, it's still considered plagiarism, but it's a minor plagiarism. So it won't be, the case won't be taken to disciplinary, and the case, the thesis also won't be affected. But plagiarism happened. If the plagiarism never happened, the committee decide not happen, it will not fall under level 1, level 2, level 3, or level 4. It consider no case to answer. Remember, if there is case to answer, it may fall under level 1 to level 4. If no case to answer, it consider no case. No level be given. Saya ulang, sekiranya tidak didapati bersalah, no level will be given. If didapati bersalah, level 1 to level 4 will be given to that particular case. Okay. If it falls under level 1, okay, bermaksud there is no disciplinary action going to be taken. Okay, a warning letter will be issued. If to a particular student, viva can continue. If level 2 and level 3, it depends on the gravity of the situations. Level 2 is in blue in color. It means that plagiarism happened. It need to be brought over to tata tertib. In tata tertib, it may fall under warning. He or she may be given reduction in rank, or been fined RM200, or been turun gaji, etc. The same goes to level 3. If the gravity is considered high compared to level 2, then he or she may receive such punishment as well. But level 4 is the intolerable one. Tiada maaf bagimu. Means that level 4, if happen to students, the viva fail. If happen to the staff will be terminated under the disciplinary action. So level 2 and level 3 give leeway to the penalties, the viva during the viva will say, or to the disciplinary actions, disciplinary committees to decide what will be the best thing. It means that it may not going to be termination or failure in the viva will say. For staff, termination. So, but level 4, it warrants the terminations as well as the if it's to the students, it falls under the failure of the viva voce. Okay, so how to decide whether it falls under level 1, level 2? We come up with these explanations on level 1, level 2, level 3, and level 4. Okay, of course, this is a general guideline. When the committee deals in each and every particular case, they have different facts of the case. I will share with you shortly because we are coming to the to that slide shortly. But look, we have defined or explains what levels in a particular investigations. Okay, we will decide which level will be the best to be given to a particular case. Remember, kalau tak bersalah, tidak ada bersalah. No level needed to be given. If bersalah, the committee need to decide which level it falls. Okay, itu yang penting ya. Okay, this is the chart about if you come across a particular case of plagiarism, how you should lodge a complaint, where you should lodge a complaint. There are two charts here. Okay, the first chart and the second chart. This is the first chart. Okay, the first chart is a special chart to a situation whereby it happened to a student during viva voce. The second chart, which I'm going to go shortly, is for the general plagiarism complaint. So why we have this first chart? Because most of the complaint on plagiarism against students are during viva voce session or during the internal and external examiners examine the thesis. So these are the most common situations. That's why we have a special chart to cover that situations. And if you are being appointed as external or internal examiners in USM, outside USM, or as a chairman of viva voce, bear in mind, if it falls under the if any of the examiners suspect such situations happen, i.e. the plagiarism happen, the viva voce need to stop. Okay, where is the source of power to stop? Through this plagiarism policy. Okay, if you are not sure whether to stop or not, remember during this session, the viva voce needs to stop because the investigation need to happen again. Need to happen first, not to happen again. Need to be conducted first. So this Tata Alia specifies, outlines the situations, how rigor the process of investigating a particular complaint on plagiarism. Look at, there are many stages because these stages to ensure the fairness to the students as well as to the staff, to the particular respective supervisors. I would say these are the procedures that need to be adhered to. Okay, we are going to the slides here. This is the general plagiarism charts complaint. If you have a complaint, for example, you suspect lecturer A just report of duty to the particular faculty and you are suspicious about his or her qualification and you found out that he or she may have committed plagiarism during the PhD time, but now he has been conferred PhD, now joining USM or your particular university, you don't know how to report it. Okay, so you use the second chart, report it to your any of your dean, or you can go direct to the vice chancellor. You can come direct to the to legal office. You can go to the any of deputy vice chancellor as long as you report in writing to the to the respective departments. What are the difference between this respective department? If you are reporting to the dean will take care of the complaint first, the first level. If you are reporting to me, for example, legal advisor, we are going to screen first whether there is a merit or there is evidence or not on the complaint. If you are lodging a complaint direct to the vice chancellor, be sure that the vice chancellor will refer to me or to the one of the deputy vice chancellors in order to take action by way of verifying the complaint. So it doesn't matter, but as long as you are reporting it, the university will take care of the report by having a fair investigations towards the complaint. Okay. Coming to the example of plagiarism, look at these examples. This is an example taken from the internet. We have example from the internet. We have examples from our site as well. Let's look for the internet first. Okay. If you look at the internet, this is you may notice this Zakaria, currently the broadcaster at CNN, quite well-known guy. He has been accused of plagiarism back in 2012. Okay, we have three colors here. Okay, we have three colors here, whereby this is called plagiarism type 3, paraphrasing. Okay, yes, it has also the patching side, but this is called plagiarism on type 3. Okay, why Zakaria, who is a broadcaster at CNN, falls under this plagiarism, not under copyright? Remember, at this point of time, Zakaria was said to be a candidate of PhD. This has been done during his PhD candidature. In that during during the PhD candidature. So yeah, people has highlighted about the plagiarism that he has done. Okay, look at the real case situations of USM. This is only an extract of it, a page of extract of it, whereby if you look at the situations of Plagiar A and Plagiar B, okay, the fact of the case is like this. Plagiar A has graduated 4 years ago. Okay, Plagiar B just graduated. Okay, so a complaint comes that Plagiar B has plagiarized Plagiar A. The investigation committee of plagiarism was wondering how Plagiar B knows Plagiar A. Okay, when that's among the issues. But of course, we need to check the complaint, and we checked the complaint. We found out there are many pages of the complaints, many pages of the thesis. They are similar to each other. Okay. By the time we were wondering how this Plagiar A and Plagiar B related, because Plagiar B was graduated 4 years after Plagiar A. Okay, so the situation was similar. Most of the things are similar. If you look at bab 4, for example, bahagian 4.5.2 at muka surat 151 to 166. Okay, so these are the thing that I can extract out from that investigation. The committee decided, yes, there is a plagiarism, and the student B was found out to be plagiarizing Plagiar A. The mode of plagiarism, or how it happened, Plagiar B approaching Plagiar A and asking the thumb drive of Plagiar A in order to help him to do a new article out of the thesis works. Okay, so when he received the thumb drive from Plagiar A, the thumb drive contains all the chapters from 1 to 5, and as a result, he used that chapter in order to and claim as his, and he thought that he will be escaping from he will escape. People will not notice about the wrongdoings simply because of it happened. No, the Plagiar A was graduated long before him. Okay, 4 years ago. But bear in mind, this case was noticed by the internal examiner, because the internal examiner in the same field, and he noticed that there's something suspicious about the thesis of Plagiar B, whereby he has read it before and happened to be the internal examiner is the same internal examiner of Plagiar A. The university at the time did make a remark of congratulating the internal examiner, because the examiner still can remember the thesis that he has read long time ago. Okay, long time ago. Okay, so this is another sharing of the findings of the investigation committee, whereby committees decide tajuk kajian calon yang hampir sama ... Of course, that ... is a tajuk. Soalan kajian yang sama, menggunakan teori yang sama, turut melihat daripada perspektif lensa tambahan yang sama. All these things amounting to plagiarism. Okay, so we have been doing this. Okay, and another example, this is the committee decide on tahap 3, whereby it was said that ahli jawatankuasa bersetuju secara kolektif wujud ciplakan yang ketara dalam kes ini kerana ciplakan yang dilakukan secara verbatim serta dengan niat, dan jawatankuasa memutuskan tesis adalah hak milik pengadu dan ianya telah disokong oleh surat pengesahan daripada pengadu. Justru jawatankuasa bersetuju wujudnya unsur ciplakan pada tahap 3. Okay, that's how it works. Okay, remember in the beginning I have shared with you the 2012 case. Now I will explain this 2012 case involving an academic still with UMT at the moment, whereby it's a quite well-known case on plagiarism. It's quite an authority case, court case at the moment, whereby we don't have many court case on plagiarism. I think this is the only court case the court has been dealing or mentioning about plagiarism in the court's decision. Remember why I said that? Because plagiarism is very seldom been brought to court, and in fact never been brought to court for plagiarism on the basis of plagiarism itself. So in this case, let me explain first. Fauzilah Saleh versus University Malaysia Terengganu is a 2012 case, about 10 years ago. The case, Fauzilah Saleh sued UMT not for plagiarism. The Fauzilah Saleh she has been terminated by UMT, okay, for a wrongdoing, and then she sued UMT because she has not been given the right to be heard by UMT. Okay, I repeat, she has been terminated by UMT through disciplinary actions for a particular wrongdoing, and she sued UMT because she said that she has not been given the right to be heard. So this case is not talking about plagiarism per se. The main contention of Fauzilah Saleh against UMT in this court is about she has been terminated without giving right to be heard, hak untuk dia membela diri. Fauzilah Saleh tidak diberi hak untuk membela diri. Okay, so however, while the court is dealing with the right to be heard, that's been argued by Fauzilah Saleh, the court also came across an issues of plagiarism. Okay, that's why the court says here in the second bullet, first, it is on the issue of plagiarism, and second, on the principle of natural justice, whether the plaintiff has been accorded the due process she deserves, in particular, her right to be heard. Okay, so in this case, the court has decided like this. Okay, I guess this is the only court case on plagiarism. It says that 35% of the plaintiff's thesis had been taken from the doctoral dissertation of one Professor Madya, Dr. Nick Kamaria. Although the plaintiff had acknowledged her sources of information, the plaintiff had failed to footnote the information source on the relevant pages. It is the duty of the university to issue students writing their thesis with a proper set of writing guidelines. This second bullet, this is the one that I'm referring to, whereby majority of the universities at the moment do have plagiarism policy. Just because Fauzilah Saleh versus University Malaysia Terengganu, the court has said so. It means that if the university doesn't have a plagiarism policy, the university may not be eligible to try to bicarakan, okay, to try any of his students for any wrongdoings on plagiarism. This is because of this second bullet that the court has decided. Okay, the third bullet, so because of the 35%, the plaintiffs were found to have committed plagiarism. Fauzilah Saleh was found to have committed plagiarism in this case. Okay, let's look on more details. Okay, the court even states that even in the absence of proper thesis writing guideline from university, plagiarism would not have occurred if the plaintiff supervisor have done his or her job, reading and vetting the contents and writing style of the student. The court even go to the functions and responsibility of the supervisors in this case. The court says that why the supervisors didn't notice that this is the part of the thesis contains plagiarisms and can be easily noticed to be plagiarized from other source. Simply maybe because of the writing style or English style, etc. The court have made some remarks also against the supervisors in this case. Okay, let's look to the finding of the court. This is the conclusion of the court on the percentage of the thesis of the students. Okay, the court decided that the first chapters consists of 30%, second chapter 20%, third chapter 60%, fourth chapter consists of 58%, fifth chapter 13%. Okay, look at the third and fourth chapter, the main among the main chapters, important chapters, but it consists of the plagiarized works. Okay, so in this case, what you need to know is that the students need to be fully aware of what plagiarism is. And in this case, even though the original court case was about the termination of her post, okay, but in this case, even though the court has found out that she plagiarized, she won the case. Okay, look at this. The court said that he had plagiarized. Everything's in writing, been taken note by the court, but the court have awarded him to win the case simply because, remember, the original cause of action is about right to be heard. UMT tidak memberi peluang kepada dia membela diri. That's why the court decide in her favor, despite the court agree that there is a plagiarism issue. So remember, in this case, right to be heard memang kena diberikan. Dalam kes ni dia dibuang kerja. Walaupun mahkamah menyatakan bahawa dia plagiat, itu bukan urusan mahkamah. Mahkamah menyatakan bahawa right to be heard yang menyebabkan dia dibuang kerja tidak diberikan kepada beliau. Dengan demikian, beliau entitled balik kepada kerja mereka. At the end of the day, in short, the court decided that she will get back her post as a lecturer. And she's still there at University Malaysia, Terengganu. So in this case, what will be the responsibility of the supervisors in plagiarism of his or her students? Okay. Remember, in USM, the thesis belong to the students. That was decided back in 2014 in our Senate. Who owns the thesis? The students own the thesis. As a result, if you ask the situation, why the university didn't take action against the supervisor, simply because first, the thesis belong to the students, and responsibility as such, responsibility of the supervisor stop there. However, in our case in USM, the universities will always issue a notice of warning to the supervisors to be careful in supervising their future students. Okay, so universiti hanya hantar surat amaran kepada supervisors in case of plagiarism issue. But if you ask me whether why the universities didn't take the supervisors to the disciplination, no such case. Simply because kita tak boleh ambil, because the thesis belong to the students. However, the good image, the reputation of the supervisors may sedikit sebanyak going to be tarnished in that case. So please avoid this so that we are in the good clear of we are in the good name. Okay. Responsibility of the internal and external examiner in reporting the plagiarism. Okay, if you are an internal or external examiner appointed for a particular viva voce, please bear in mind you have the duty to report it to plagiarism. Because if, let's say, the case has been reported after he or she graduated, after he or she has been conferred the degree, PhD, etc., then the university will go back to the viva voce and will also question the internal and external examiner whether they are aware about it. Okay, particularly there will be no good defense if it is a clear manifest plagiarism. If it's not clear, then that's fine. But if it's a clear manifest plagiarism, then it's not easy for the appointed internal and external examiner to defend to defend their versions. Okay, I would like to Prof. Karim has mentioned just now about a particular developments, new developments in case of plagiarism. This is a new slide in my webinar. Recently, the university has received report against this name, Course Hero. Many have heard about it. Many also, I guess, do not know about the existence of Course Hero. Course Hero is an online vault, I would say, online online website whereby they gather all the academic materials, including the past year questions, including the articles, class notes, anything that going to be uploaded by any individual, but in our case, mostly by the students, and then it can be downloaded at a fee. Okay, the modus operandi of this course hero is like this. Even though I said the fees just now, an individual, a student or us, okay, we have two options in order to subscribe to the course hero. Either we pay a certain USD dollars to course hero. For example, we pay 40 USD in order to get access for 2 days. So during these 2 days, we can download anything in the course hero, okay, for that 40 bucks. Okay. Alternatively, you don't need to pay this $40, but you need to upload at least 5 materials, course note, your class note, etc., to course hero in order to be eligible for 2 hours time to download anything in the course hero. Okay, so this course hero, their operations is quite interesting, whereby in order to ensure they have a very powerful contents, they allow for a free access provided a particular individual, in this case mostly our students, to upload it for free, to get access for free by uploading at least 5 materials. So they get 2 hours free. Or if you are not going to do that, you have to pay USD $40. So this is the modus operandi, the business of modus operandi. Okay, what happened? We have received about few complaints from our deans saying that their course notes has been uploaded in the course hero illegally, without permissions. Okay, so in this case, what we're going to do, bear in mind, to all listeners here, Course Hero has been in existence. Some facts for Course Hero company. Course Hero has been in existence since 2006. The Course Hero originate from US. They comply with the US copyright law. Okay, they are a company worth USD 1 billion. 1 billion. They have subscribers worldwide. I don't know how much actually the amount of the contents or courses, course notes that they have. But from USM alone, we found out that they have 19,000 plus, 19,000 lebih courses that have been uploaded to the Course Hero. So even though we have just received the information, the complaint recently, but it means that sudah ngantuk lagi tengadah, because there are 19,000 notes that have been uploaded that related to University Science Malaysia, the keyword University Science Malaysia. So what would be the best way to do this? Remember, I said just now, in order for us to sue people for copyright law, in this case it's not plagiarism, it's copyright, we need to sue in that particular country of the wrongdoers. Okay, that particular country, in this case, is US. Okay, so our problem is that Course Hero has complied with the US copyright law. If we are suing them, they will not be anything worth for us to sue them, because they are complying with the US laws. They may not comply with the Malaysian law, whereby the permissions of the original author has not been obtained. But in US, if they assume that the permission has been obtained, they can still upload it, provided, this is the main thing, if there is notification to them that it has been uploaded without permission, okay, they have to remove it. They have to take it down. So they have such clauses whereby if a particular note does not have any permission from the authors, let them know and they will take down the notes. Okay. So in this case, we don't have uh, uh, um, we will not have the opportunity to sue them, because before we sue them, we need to notify them to take down the cost, the notes. Okay. Because the US law says so. Okay. So even though in this case, we have a lot of unhappy academics saying that their notes have been uploaded without their permission. So I have urged them to list down those notes and then write to us, because our office will need to write to Course Hero and notify them to take down those notes. Okay, so it will take some time, because their modus operandi is that they comply in the US law by having a paragraph saying that notify them and they will take down. So I don't know whether we can take down those 19,000 course notes, and even if we have, I don't think many of us will concentrate on that, or rather let it go. Okay, so this Course Hero operates at the moment legally in US, and they are receiving a lot of good response from other countries outside US as well, including Malaysia. And if you browse or you search for Course Hero, you will find a lot of course notes inside there. Maybe your notes as well, if you are searching correctly. Your note also has been uploaded, and that's how they get away with copyright law. That's how they also worth 1 billion at the moment. And please bear in mind also, those notes that have been uploaded, they may be past year questions, etc., that may belong not to us, the author. We may think that it belongs to us, but bear in mind, I need to caution all, if we think that it belongs to us, whereby we are also taking our notes or our past year question from the publisher books, it's not ours. Okay, the original author is the publishers. Okay, so in this case, we acknowledge that also there are some situations in some particular aspect of fields that a past year questions or a student notes come from the publisher's book. Okay, so this issue also need to be discussed before we are taking actions for Course Hero. At the moment, the only course of action against Course Hero is to notify them. That will be the best, not confronting them by whatever means of court legal tussle, but it should be by way of diplomatic way. We should do that. Okay. I come to another new slide of Turn-in. I receive a lot of questions about this Turn-in, whereby we know that Turn-in is one of the applications that can track the plagiarism issue. But the main questions come out is that how many percent the university really consider as plagiarism? Okay, the answer is none. Even though the IPS or at your university, the general rule is that no thesis can be submitted if it exceeds 20 or 25% Turn-in result. Okay, but in reality, plagiarism is plagiarism, even if 1%. Okay, but you need to consider just now. That's our loophole during our first versions of our plagiarism policy. That's why we come up with level 1 to level 4 plagiarism policy. That's depend on what are the levels of the plagiarism. Okay, maybe if it's a 2%, it's still considered plagiarism, but it's a level 1. But if 2% at chapter 4, for example, the result, it may be level 2 or level 3. Okay, but if it is 70% Turn-in result, of course, it will be level 4. So to answer the question, there is no really percentage about considered as plagiarism. Okay, even 1% is plagiarism, but generally I agree that we accept that more than 20% or 25%, that particular thesis should not be submitted. I agree with that. I agree with that. That is a general rule that you can, the institution can come out, but under the law, it does not matter. Even 1% percentage is also considered as plagiarism. So I just would like to repeat on this in one of our examples shortly. Okay, in one of the case that we're going to find example. So what are the causes of plagiarism? This is not a cause. What is the implication of plagiarism? Plagiarism means that your degree can be withdrawn. So how to withdraw it? Our constitution say we can withdraw it by way of 2/3 of the member of the board convene to decide the issue. Okay, and the board agree that he or she is guilty of plagiarism. Okay, so it must be 2/3 of the members of the board. Okay, in order to enable that particular degree to be withdrawn from that individual. Okay, so we are going to look at the case of plagiarism. So this is the general things. 2017 we have 4 cases, for example. Okay, 2018 again we have 3 cases. Okay, okay. We have staff ... example, etc. So, but 2018, both case number 1 and case number 3 is considered level 4. It's a clear manifest plagiarism. But whereby in 2017, 1 is at level 1, 2 at level 4. Okay, okay. 2019 we have 4 at level 4, level 1, and 1 at level 3. Okay, okay, and 2020 I haven't updated it. Is there were 5 cases in 2020. The first 3 original case in January 2020 was tahap 1. The 2 new cases were level 4. Okay, or level 4. Okay, experience from USM. I don't have time. Let us go to the item D. What is an example of the percentage, etc. It can be, we can get it from example from experience from a case number D. Okay, this is one of the unique case. I would say the most difficult case that we have ever tried in USM. Okay. The case happened in 1994. I would like all the listeners to try to visualize the situations. First, I would like you to visualize 1994. How old are you? Second, whether in 1994, do you think that there is a computer and proper printer at the time? Next, I would like you to imagine whether turning in is still there. Next, I would like you to imagine whether the awareness about plagiarism, is it widespread? And last one, in 1994, do we have any WhatsApp, WeChat, email, etc.? So before I start revealing or discussing the fact of the case. Okay. This is a very uncommon case. I don't know. Very isolated case happened. It happened in 2015. In 2015, the university has received a complaint from a particular students, from a particular lecturer, docent in Indonesia. He wrote a very lengthy letter of allegations against a fellow colleague of his in Indonesia who was an ex-student of USM. This ex-student of USM studies in USM in 1994, graduated in 1996. Okay. The complainant was saying that our students have plagiarized his PhD thesis. He has done his PhD in University Indonesia back in 1989. He finished in 1989. Our ex-students was a master students back in 1994 in USM. Okay. So they were colleagues, they were close friends at one time. But when our students, who was a docent at the time, became a dean at that particular university, there was a hard feelings between them. As a result, the complainant came to USM and formally lodged a complaint about the plagiarism issue. Okay, to make the thing worse, the title of the thesis of our master students is in bahasa Melayu, or maybe also can say bahasa Indonesia. Datuk Sri Saleh here, Datuk Sri Saleh was one of the committee. So university has set up a special committee for this, consisting all the senior professors. I was one of them. I'm not the professor at all, but I'm the only administrator in that particular committee. Okay, when we look at the thesis was about 312 pages. It's in bahasa Melayu, master. 312 pages for bahasa is quite thick thesis. Tajuk, the title of the thesis was something like Putri Hijau, something like that. Was something like to do with Putri Hijau. When we look at the details of the thesis and the evidence provided by the complainant, we found out at least 8 pages out of 312 pages were direct plagiarism from that complainant. We agree with that. There was a direct plagiarism by our master students from that complainant's thesis of PhD. Obviously, the complainant thesis should prevail because he graduated in 1989. Our ex-student graduated in 1996. So that's for obvious reason, plagiarism may happen in that particular aspects. So we found out also they are friends, okay. And then when we call up our students, he was a dean at the time. He said that he of course he shared with us the story about how the fiasco happened. There was an envy from his friends, etc. And then as a result, the complaint happened. And this is among the important remarks from him. He said that yes, he copied. He confessed that he copied blanketly, in verbatim, from the complainant's thesis. Okay, because they are friends at the time. He copied simply because the complainant offered him at the time, use my thesis for your master thesis because it has we are doing almost the same topic. So because of the pelawaan, he did copy that in verbatim. Didn't put any proper remarks, citations over there, but he said that he did the citations in the other way around. He did, when he has read some books, he said that he cited the original books, not the friends punya citation, because he said that even the friends also didn't use the right citation because that particular paragraph came from the other books. Okay, that was the thing. So the committee have a difficult task in order to trace the original book that he has mentioned. And then we cannot find the whole lot, but we do find 1 or 2 books that may be relevant at that time. But bear in mind at the time, the main thing is that 8 pages out 312 pages. 8 out of 312 pages, the whole thesis. that is how much will be the percentage of the thesis. Okay. And then the committee has the task to also decide the main issue. If the university decides the master's thesis need to be withdrawn, what will happen to his PhD? Because he has PhD from Indonesia as well. Okay, what will happen to his job? Another thing. But what will be next? What will be happen to his PhD? Because the enrollment criteria for his PhD came from his master thesis, which was from USM. So there were many issues that has been discussed, but at the end of the day, I just would like to share with you the decisions of the committee. The decisions of the committee found out that he has not violating the rule on plagiarism. So the whole thesis does not consider as plagiarism. So you may not be happy. You may query me. You may query the committee as well. Why this decision, such decision has been made? Okay, it has been made first mainly because of the percentage of the plagiarism. But the most important part I would like to share with you, in 1994, there is no proper printer and there is no proper computer at the time. No notebook at the time. The thesis was done in typewriting by typewriter. Okay. At that time, there's no such deleting, etc. It all need to be used by liquid paper. So there was a liquid paper here and there in that particular thesis. Okay. Next, we found out that how the plagiarism happened, because at the time there is no Google, etc. For the student to be easily cross-referred, etc. Because it need to be all physical reference, because that complainant has provided a physical copy of the thesis to him, and that's why he has been referring to. Next justification is that look, he has cited a proper citation by referring to the original author, whereby we found out that the complainant may not have done so. Because we may not, we are not empowered to inspect the whole thesis of the complainant, but we suspect the complainant may not be doing the citation correctly. But in our case, our student may cite the original author correctly. Bear in mind, it's not a justification for the complainant to for the student to use the complainant's thesis simply because of the complainant agree. No such thing. Even though the complainant agree, it's still considered a plagiarism. Okay, as long as there is no acknowledgement to it. Okay, so in this case, the university decided that there is no plagiarism in this particular aspect. So we have few cases of plagiarism and cheating on online exam, but we have been learning from these cases. To be honest with you, last semester we have roughly about 15 cases being referred, but all considered non-cheating or non-plagiarism. This semester, last semester, we received about 12 new cases, but 9 was considered there is a case to be tried. So 9 cases of plagiarism and also cheating during the online exam has been going to be brought over on 7 April next month. Okay, this is among the last slide to me. Remember, I want to share with you one of the Seniman Negara that has been we shared just now about the moral rights. Remember, a material, a publication, a book that you have done during the course of your employments belong to the university. However, you still retain the right as a moral author. So in this case, what happened? Datuk Syed Ahmad Jamal, arwah Datuk Syed Ahmad Jamal, who was one of the Seniman Negara, has donated his his ciptaan dia, his inventions of art archer dia called Puncak Purnama or Lunar Peaks to DBKL. So he donated his arc to DBKL. DBKL built the arc based on the drawings, his drawing. So his drawing is a copyright. Okay. DBKL has come up with their own money to build it. And this is the Puncak Purnama design. So the design was done by this Seniman Negara. Okay. So it was donated free to DBKL. Okay, when DBKL received it, this Puncak Purnama back in 1986, okay, DBKL, of course, DBKL didn't pay anything because it's free. But in year 2000, the mayor has done a major renovation to the ark, okay, without the consent of Seniman Negara. The DBKL didn't obtain his permission, and as a result, demolition happened. Okay, it has been demolished without the consent of the author, and at the end of the day, they build up the new things by stainless steel. Okay, at the moment, the whole ark has been removed, has been demolished, but here I would like to share with you the court says that the fact that DBKL didn't get the consent from the original author, the Seniman Negara, the DBKL has violated the copyright of him. And as a result, 750,000 worth at 2010 was awarded to Datuk Syed Ahmad Jamal. He received this 750,000. Bear in mind, originally, that art was given free to DBKL. But simply because DBKL didn't get his permission, DBKL has renovated it without the permission, demolished it, and replaced it without his permission. So the court says that there's a clear violation of copyright, and he has been given 750,000. So remember, this is copyright, not plagiarism. It's nothing to do with academic. It's something to do with copyright and compensation here. So as a result, from the original drawings, they've demolished and they built a new one. The court considered itself violating the copyright of Datuk Seniman Negara. So the last one is that do not commit any copyrights, copy wrong, sorry. And of course, there are many things that we can try to avoid those plagiarizing issue. Okay, 4:15 roughly now. I finished my sessions, Prof. Karim.
Okay, thank you very much, Dr. Khairul. Wah, berasap kepala lah. Okay, Dr. Khairul. If you can look at in the chat, the question. I have asked the participant to put Q, capital letters Q in front of the question. So maybe you want to pick up those with the Q in front first, maybe from the top.
Okay, let me stop sharing first.
Yeah.
Okay, I go to chat. Is it, bro?
Yeah.
Something chat. Then I go to. I'm in the.
Yeah.
Those, yeah.
Start from the top. Then the question should be. You should see Q, capital letters Q in front of the.
Okay.
Yeah.
Question, capital Q. Okay. So okay. Thank you. Okay, Q. English language. Now on. Okay.
English language ni tak tahu apa. What's the context?
Okay. Q, line not clear. Betul. Okay. Saya sabar. So explain. Okay, saya tengok Q ke saya tengok semua ni? Ada juga yang ada yang bukan Q ni.
Yeah, okay, tak apa tahu.
Okay.
You can see it. Yeah.
Okay. From Anna, you can't protect idea until you express it in some form or tangible format. Yes, correctly. Yes, you can't protect your ideas. Ideas, I want to build a car that can fly. You can't protect it. Even though at one time in US, there was a law saying that in provisional patent, it's not copyright, provisional patent, you you can protect your ideas provided it must be realized in 1 year. But in Malaysia, the law doesn't exist for us to protect an idea. So that's the answers for it. Aspect intangible, such in writing, yes. Copyright, you need to be in writing, you need in writing or reduce it in any medium. For example, painting, yes, photo, music compositions, etc. It's all falls under copyright. People ask whether applications or applications come under copyright or not. Yes, applications come under two types of protection. It can be copyright and it can also be patent. It depends. So how to differentiate between patents and copyright? Make sure that if you think that there will be a revised version in the near time, you just protect it under copyright. But if you think that this is the product that will last at least 20 years, 10 years, yes, you can patent it. Simply because you need to understand patent, if you file today, you have to wait for 3 to 4 years down the road in order to get it granted. Whereby copyright is on the spot, is automatically protected upon creation, whereby patent you need to wait until 3 to 4 years to get it granted. So what are the difference is that if an act you think that it can survive more than 10 years, protect it through patent. So we will advise, if not, you think that there will be a revised version 1, version 2 in this near time, just protect it under the copyright. Okay, express and enable, even in draft, okay, yes, even in draft, provided in writing. The law doesn't say whether it's in draft or not. The law says as long as it is in writing, okay, it will be automatically protected. So how to say that if you are put it in writing but put it into the drawer and nobody knows about it, as long as it is in writing, it is still protected even though it's not published. Okay, but here we are talking about how valuable is your thing. If you are putting it in drawer, we don't expect the material to be worthy. For example, my slide, I don't think my slide can be worthy. Okay, so it's okay for you to take up my slides because the worth part comes from the explanations. Okay, so it depends on how we look at on particular situations. Okay, aspect tangible, even draft pro by, well, how about student? How about if the student publish the work without the lecturer's consent? Wrong, it's wrong. The student cannot publish the work without the lecturer's consent, provided the lecturers has some contributions, input to it, Dr. Rajendran. Okay?
Yeah, Dr.
Yep.
Khairul, can I just interject?
Yep. Yes, Ken.
Thank you very much for your session. It's very, very, very nice session. I learned a lot. My case, what happens is, like you said earlier, I've developed 2 models and 1 career of mine. I've written articles on it. I've published books on it. So most of my PhD student works on it. Okay, like you say, the thesis belongs to the student. The one student leave USM, can they publish without us?
Yes. Okay. There are 2 separate issues here. The thesis belong to the students. However, whatever your inputs there, it still belong to you. This is where about the ownership of the my last slide just now about the ARC.
Correct.
Remember, even though the Seniman Negara gave it free to DBKL, which to our mind, layman, say the Seniman has given it free. Why now he's suing the DBKL? Definitely he will lose the case. This is our original thinking. Many of us think like that because simply the fact that he give free to DBKL. But remember, the law says you still have the moral ownership to it. So in this case, even though the students, DBKL, equal to students at the moment, even though it belongs to the student, because you as lecturers, supervisors, have input into it, you still own it. So if the student want to publish, they need to get the consent from the lecturers. Simply like that.
Okay, another question. Another question. Like you're saying that the difference between copyright and plagiarism, right? So if somebody found out that a staff from USM copied something, can the person sue the university instead of suing the person directly?
Okay. If you found out, what will be your main intention? If you are asking for RM compensation, I would say you need to sue it under copyright. But if you want to sue him for the academic integrity, under the academic scope, for example, he need to be taught a lesson for this under the academic penalties, you complain it under plagiarism. Okay, because if you complain under plagiarism, the university will investigate to it. Once the investigation happen, if that particular article, for example, has been used in the promotions, exercise promotion, okay, the disciplinary committee may need to consider what would be the best option of disciplinary against he or she, because he has used the plagiarized work in order to get promotion, despite there are many other original works. Many other original works, but if we are giving advice, we say that termination may not be the right one, but reduction in rank may be possible, may be the best possible. You know, these are the things. These are the things that we need to consider. But if you are looking for RM, because he has made money out of your copyright items, okay, then sue it in court.
Okay.
Okay.
One more last question. Yep. You see, you said whatever we create, we publish, either in terms of book, in terms of article, and etc., you already consider as a copyright, right? So then what do we fill up in the ACMS? Maybe Prof. Karim, what do we fill up in the ACMS? There's a column for copyright. I don't understand what is that column for.
I didn't get it.
No, in ACMS, there's a column says copyright.
Oh, okay.
What do we fill up there? Because you say once I publish article, my theories, models, all are copyrighted automatically.
Yeah.
So what do I fill up there for social science especially?
Oh no. That is for the purpose of to collect or gather your writings. But they use the term copyright. My explanation just now, copyright under the eyes of the law. Okay, it can be your ACMS, for example. It can be your articles and / journals, articles, for example, writings, for example. It can be done that way, but it has been termed as copyright, means that it's almost referring to the same thing. As long as you have articles, it's all copyrights. But my explanation just now is copyright under the law. You see what I mean?
So my question, Doctor, for social science, what will be considered copyright, which can put under that column?
Anything, as long as in writing. In our academic situations, as long as writing, as long as it is in tape recording.
Okay, that means MOOCs is one of the example lah.
Yes.
Okay.
Of course. Of course, MOOC is one of the examples. The good one is also MOOC, no problem.
Thank you very much. Very nice talk. I learned a lot. Thank you very much.
No problem, Dr. Rajan. Another word did not include.
So see you in court, yeah?
How about the student? If the student published the work without the lecturer's consent, another word did not include. No, it cannot be done. Prof. Karim, ignorance is not a bliss. Ignorance is not a bliss. Ignorance is not an excuse. Ignorantia juris non excusat means that ignorance is not an excuse. So that's a good question that will be covered shortly. Fair use, use sparingly, judiciously, be fair. Can we plagiarize the plagiarism policy? Okay, good thing. Prof. Karim, from Dr. Allah. Can we plagiarize the plagiarism policy? Okay. I didn't cover that just now. Okay. Apart from the fair use just now, the law can be copied without any. It's not wrong to copy law, undang-undang. So it means that our plagiarism policy is one considered under the section of rules and regulations. So it's not wrong to copy the law in verbatim. Malah in law, you need to cite the law in verbatim. That's how the law works, in verbatim. Ayat demi ayat tu kena sama dengan law, because we don't want to have misunderstanding on the law. So, for example, if for better understanding, our Indian Penal Code and Malaysian Penal Code are in verbatim, one-to-one, verbatim. So the law can be copied. So it's not joking, Dr. Ala. Okay, next. Yeah, you send to private. If publish a book using outside publisher or self-publish, who will hold the copyright? Me, university, penerbit USM, you science. Okay. If I publish of a book using outside publisher or self-publish, who will hold the copyright? Okay, the copyright will be held by the outside publisher. Okay. Of course, the outside publisher, because you are using the outside publisher. But the outside publisher is only holding the copyright to publish. Okay, you are still the author. You never pass your authorship's copyright to the publisher. Okay, so the same goes to the university. If you're the university press, USM penerbit done it, so it belongs, the copyright to publish goes to penerbit USM. So copyright to publish means that if you are giving it to penerbit USM, tiba-tiba you nak pergi penerbit UPM, contoh. Penerbit UPM, you cannot go to penerbit UPM anymore, because you have gave your right to penerbit USM. Simply as that. Okay. So if we take a diagram from the public domain, internet, and do little bit of editing, such as mirror and flip it, and adding a different labels and legend, do we still to quote the source? Yes, you need to quote the source. It's a myth to say that anything in the public domain or internet is free. No. We have a case in USM whereby one of our staff have taken 10 photos from the internet. Okay. Yes. We thought that is okay. I received a call from a particular individual saying that your university have stolen my photos. Better you pay 10,000. I told him, look, how long you have been a scammer? He didn't answer. He said that your university is wrong, and now you accuse me of scam. No, I didn't know you. Suddenly I pick up the phone and you told me that my university has stole photos from your site. You need to inform what photos are there. No, your university have taken photo. You are unethical, etc. So I said, rubbish. Look, if you want to claim on that, just sue the university. So I hang up the phone. Okay. To all listeners, listen. I honestly thought that was a scam phone call. Remember, we have a lot of scam phone calls, etc. It happened in year 2016, if not mistaken, or 2015. Okay. Even though, even you can search for that inside the Google. My name has been mentioned as not cooperating with him lah. Nanti I akan bagi tahu sekejap lagi. So, I sincerely thought that it was a scam. Until suddenly it reached the university level, whereby the university has received a Facebook remark saying that the University Science Malaysia has stolen the photos from this internet belong to one guy. Then only I realized that this is not a scam. This is a real. So this photographer has put it into his Facebook, alleging that USM had taken photo, put it into our former website without his allegation. So when I look at the photos, it was something to do with Komtar, it was something to do with Penang Bridge, etc. A very nice photo, etc. So I call up the particular respective PTJs, asking for details of it, and that staff in charge said that no, this is from our staff. I said, how can this guy claiming in the Facebook said is his but not ours? but our inside story say that it come from us. So there was a different version. So I was still thinking that it was a scam back. It's a scam. It's a scam thing again. Until again there were many remarks alleging USM to be unethical for that, etc. So we do a proper check. We call up the staff again, then only the staff admitted something like this. Yes, he has taken it from the website. From a website, there was even a watermark on that 10 images. He has cleaned up the watermarks. Okay, the watermark was something to do with Getty images, Getty images. You know, Getty images or Shutterstock, you need to pay for it. I said, why you did that? He said that he didn't know about Getty images, that's fine. But why we have a lot of photos from USM, etc. Why we take up photos from the ni? Because it's too cantik gambar tu. Memanglah cantik, but it's not too attractive pun. But yeah, it's a fair good one, good photos. And because of it was viral that USM has not respect copyright and has stolen something from photographers. We need to call up the photographers, okay, asking for settlements. At the end of the day, we settle with roughly 10 photos for 10,000. If you Google my name, I think Khairul, photographer, curi. There was something about the stories because he didn't delete that posting. Okay, but originally we thought there was a scam, but after we further investigate, then only we knew that our staff has taken his photo without permission. So it's a myth saying that as long as in the website you can take up as yours. No, particularly those images with the watermarks of Getty images or Shutterstock, do not do it. Okay, so we take, can we verbatim from Wikipedia? Yes, you can do verbatim from Wikipedia simply because Wikipedia agrees to it. They allow that to happen. Okay. Okay, but if Wikipedia didn't allow later on in future, I don't know. So you cannot copy it simply. But at the moment, Wikipedia allow it to happen. How can we report it directly to the pegawai at TNC? Anybody, you can report it to anyone. But I suggest directly go to the TNC rather than to the officers at TNC level. If it's undergraduate, for example, just lab report. Okay, report it to the dean of that particular PTJ. As for the IPS regulation, the plagiarism will be checked by IPS TC submission. So I suppose the TC is screened for plagiarism before the Viva, or would there be another checking for plagiarism at higher level? Yes, it will be screened at IPS. So now I was told that it will also IPS didn't check the thesis plagiarism, turn it in. That will be done at your school level. As per the IPS regulation, the plagiarism will be checked by the IPS. Okay. To what extent of plagiarism that the thesis should be reported to IPS level? As long as you find a reasonable substance of plagiarism, report it. Let the committee decide about it. Okay, as long as you found any plagiarism issue. Okay, you will have your you will have your feelings that it exceeds the level of allowed plagiarism. You should report it. This you. Bila cerita about plagiat ni, kes ni memang selalu disebut. Okay. Kes mana tu? Boleh buat case study ni. From YouTube, turn in is commonly being used to check plagiarism. What is the maximum similarity in that study? Kita most of the university between 20 to 25% allowed to submit for thesis. However, like I said just now, even though it is 5%, is still considered plagiarism. But plagiarism in the literature review, we treat different from the plagiarism at the finding results. Definitely there is a different gravity to it. I repeat, plagiarisme sekiranya dijumpai di peringkat di literature review berlainan ya dengan plagiarisme yang dijumpai di peringkat finding. So how we deal it, that's why we have level 1 to level 4. We deal it differently. Sebab we have cases whereby plagiarism is at the level of literature review. Let me share with you one example. In 2017, I have the opportunity to discuss the level of plagiarism with at the UN level in Paris, whereby I have to say that in 2017, those scholars, experts in plagiarism, in US and in Europe, they are talking about literature review, there is no plagiarism. I don't know what happened at the moment, tetapi Malaysia tidak bersedia. Meaning that if we found out the plagiarism at literature review, to them is not plagiarism. Why is not plagiarism? Important. They said, in literature review, you need to understand the subject matter, whereby if I'm the original author, I want my writings to be taken in verbatim by the students, not to be paraphrasings or what? Not to be interpreted as to the students punya whim and fancy, they said. I want it to be in accordance to what my writing is. So betul juga ada logiknya, because bila kita tak benarkan in verbatim, that's why people student paraphrasing it, and as a result may not dive with what the original author was talking about. So ada idea. Tetapi they will not tolerate at the findings and finding results. They said that will be a serious issue. So in USM, we adopt such view informally, meaning that we treat different sekiranya berlaku di literature review. Bukannya treat it different sampai tidak bersalah, but we will allow a chance to rectify, to remedy. Okay? Oh, 4.5. Prof, macam mana Prof? 4.45 lah.
Okay, maybe we try to cover as much in next 10 minutes maybe, the most.
Okay. Soalannya Prof, soalannya, we have problem, then what we were advised not to test or check plagiarism before submission. No, you have to check your plagiarism is a requirement, but at your school, not IPS. IPS does not check plagiarism at the moment. Turning in has been authorized at the school level at the moment. We have privately saya tak boleh baca. Other graduated students uploaded my PowerPoint slides dekat script. Yes, it's a considered as a copyright violation, even though PowerPoint. Okay, we have a problem. It can be also plagiarism kalau PowerPoint yang asalkan berkaitan dengan akademik. We have a problem. What this is? We have a advice not to check. Okay, graduated students. We have a problem. Sometimes the protocol follow may be quite similar as the kit may be from the same company, and in that case, similarity index may shoot above 20%. So it's considered plagiarism. Yes, it's considered plagiarism. Okay. Especially in methodology. Yes, especially in methodology and findings. The case of plagiarize the plagiarized work, double jeopardy. The case of plagiarize the plagiarized works, double jeopardy. Oh, Prof. Oh.
Don't worry about that. Don't worry about that.
Okay, pening kepala je ni. Memang complicated. My master thesis use typewriter. Okay, my master thesis use typewriter. Yes, betul. Problem saya rasa ni. Bila kita buat thesis, supervisor and co-supervisor ada untuk review. Suppose dah boleh check plagiarism atau tak. Yang terjadi terlepas detect ada plagiarism. Siapa yang student patut dipersalahkan. Okay, supervisor and co-supervisor, their task is to guide. Okay, but the original things is that hanya students tahu dia plagiarize ke tidak. So tambahan pula USM dan beberapa universiti lain memang mempunyai polisi tesis milik pelajar. So definitely pelajar yang akan dipersalahkan. Untuk makluman, kenapa universiti membuat decision demikian bukannya atas plagiarized work. Waktu keputusan tersebut dibuat di Senate, ada two school of thought pada waktu tersebut, saya ingat lagi. Tetapi universiti membuat keputusan tersebut simply because of there were many students PhD when graduated they publish in the tahap apa punya publisher, and then when they publish it sometimes the whole thing of the thesis ada spelling mistake dan sebagainya, semua spelling mistake tersebut appear dalam publication tersebut. So that's why we want to avoid that. We don't want this to happen lah. The universities tarnish the image. If the students copy the exam answers from the internet and turn it in is more than 20, can USM take any action against them? No. USM will still need to investigate what are the similarities of 20%, because sometimes similarity, if in law, are allowed. Sometimes the similarities are allowed by nature, by way of memang you kena copy paraphrase. So we need to investigate. So we can only take action after we investigate. So we investigate dulu lah. In methodology of thesis, many times the protocols are same as the kits are from the same manufacturers, and hence the similarity index may be above. So this falls under plagiarism. Many times the protocol are same as the kits are from the same manufacturer, and hence the similarity. Okay, if you can justify it, it may not fall under plagiarism. It may fall under the law punya requirement. So what I will understand it, the protocols can amount to law, the rules and regulations. So I didn't want to delve much onto your questions, other than to say if the protocols are falls under the law, are in the field of law, so it is allowed. Okay, may I know how the university is going to resolve when lecturer won an award or his or her project funded by a grant written by him, but the work was done by his or her student for an academic thesis? Ini interesting, eh? Since the ownership of the thesis is given to the student, is there any possibility that the student can sue the lecturer and dispute the award? No. Okay. Ada beberapa isu. May I know how the university is going to resolve when lecturer won an award on his on her project funded by a grant? When the lecturer won an award funded by the grant, is by way of the grant. The grants belong to the lecturer. Full stop. Habis. But the work was done by his or her student for an academic thesis. Academic thesis is different thing from the grant. He won the award by virtue of the grant, not because of the thesis, even though that the write-up was in the academic thesis. Remember, the lecturer also has some stake in the academic thesis. So it's not violating any issue of copyright or even plagiarism. Since the ownership of the thesis is given to student, yes. Remember, the lecturer also have some stake in it because he's the guidance. He's also the contributor as well. Although the ownership of the thesis belong to the student, tapi ada moral rights of the lecturers dalam thesis tersebut. So tak ada masalah langsung dalam case tu. So student cannot sue the lecturer to dispute the award. Okay, because simply first thing first, the award came from the grants, not from me. The grant came from the grant belongs to the lecturer. Do I need to copyright my thesis? No need, because automatically copyright protection has been conferred to your thesis under the law. No need. So automatically you dah ada right thesis, asal lengkap saja, even dalam draft pun dah jadi yours, dah di-protected. The submission of transcript by lecturer or the students, my concern is awareness and tracking of the manuscript settled because a few FTS allow the lecturers to perform the submissions. Yes, to you. A colleague used my PowerPoint, which I have copyrighted, and then she removed me as an instructor in the course, although I am available. Cuti belajar, salin. I never give permission to her to use my PowerPoint. She got it from previous student. Okay, I have informed her that I have copyrighted my work. I never allowed her to use it through email, WhatsApp, and passage to NTD, but she's still using the slide after years. I said no. She never. When can I report? Yes, you can report it. First, you report it to your decan. But if you have reported it and no action, you can extend the report to the higher authority. Here, the best is either TNCAA, or you go to the ombudsman, or you go to myself, PUU. No problem. We will investigate it. For example, we received another complaint, another plagiarism complaint last 2 days ago from outside university, alleging one of our new lecturer as plagiarizing his PhD thesis. So we have formed a committee for that. Okay, sama ni. Colleagues use my PowerPoint. Do I need my copyright my thesis? Okay. To what extent does a graduate students cannot publish his OTC in his own? What about review paper that does not include any data policies but related to this? Yeah, students are allowed to publish their own thesis, no problem. Simply by virtue of 2014 punya Senate rule, because the thesis belong to he or she. Is an audio recording of a newspaper book violating the copyright of the owner? No, because an audio recording, if he didn't read your article, is considered no. But if he read in verbatim your article, yes, it is considered as violating the copyright. So you tengok ni macam mana the link YouTube, to what extent the link will be active. In the case of 10,000 copyrighted photo, is the photo used for income generation? If one put such photo on teaching site, would get the same impact. Okay, the 10,000 compensation that we paid just now, is the photo used, the 10 photos used for income generation? No, it was used in one of the PTJ's website, but for all our university staff. Okay, so it's not for income generation. But however, this is the power of the media social. The university have been bombarded kiri kanan because of that issue. Sebab tu saya maklumkan, kalau you semak dalam Google sampai sekarang pun ada lagi, dan you boleh baca macam mana universiti been bombarded kiri dan kanan. Saya pun been bombarded kiri dan kanan simply because I mistakenly thought that it was a scam. Okay, so bila it was a scam, kita tak layan. Bila tak layan tu, dia nampak kita universiti sangatlah tidak bertanggungjawab. So it started from there. So memang kena teruk lah. Okay, I would take approach to share. The link will be, I would take approach. Okay. Thank you very much. Okay. Sharing screen. Okay. Yeah, okay. See. Okay, Prof Karim, saya dah baca habis dah semua. Saya rasa cukup 10 minutes.
Alright. So saya rasa I think time is not on our side. I guess Dr. Khairul has provided some insight, or a lot of insight, on many issues and aspects of plagiarism and also copyright. So we have tried to answer many of the questions, but I'm sure there are many things remain unanswered because copyright and plagiarism is such a complicated topic. But I hope our session today have managed to shed some light and provide some insight to many of the common questions on copyright and also plagiarism. So I would like to thank Dr. Khairul for your input, for your good, good knowledge sharing this afternoon. So ladies and gentlemen, let us show our appreciation. Use the icon down there to give him a big round of applause. Thank you very much. Thank you very much, Dr. Khairul, and thank you very much, everyone. The recording of this session will be available on YouTube. Yeah, and anything else? A final word from you, Dr. Khairul?
Nothing more, Prof. If there is any personal questions, kindly email me at kaha@usm.my, KHA. I will try to respond it within 24 hours. Okay, personal email. Okay, itu saja, Prof.
Okay, thank you. That would be very, very useful, Dr. Khairul. So once again, thank you so much. And that's all for today. And we'll see you in our tomorrow. On Friday. On Friday, we will have another webinar session by Mr. Chua Kiman.
Tomorrow, Prof.
Tomorrow. Tomorrow. Okay. Tomorrow. And don't forget, for USM staff, please don't forget to fill up our borang penilaian to get your CPD point. If you fail to fill up that borang, well, come for another webinar to get a CPD point. All right. So thank you so much, and bye for today. Assalamualaikum warahmatullahi wabarakatuh.
Okay.
Thank you, Dr. Khairul. Thank you so much.
Thank you, bro. Thank you.
Time.
Thank you, bro.
Thank you.